Enlightening hearts and minds. In this case review, I'm going to look at an appeal that was just dismissed in the Royal Courts of Justice. Judgments are one of the best indicators on how the court will interpret law and your submission. If you want to represent yourself in court, or simply you're just interested in how justice is decided, this is a great case to learn from. So let's get started. Firstly, if you're not familiar with the Royal Courts of Justice, it is in London. It is also known as the Law Courts, and it is divided into a number of divisions, appeals for both civil and criminal, and the High Court, which it deals with 3 divisions and disputes over £100,000. They also have a family division. I have had cases in the High Court and the Appeals Court. The building is huge. It is literally a maze. There are 100 courtrooms, including 20 main ones. My cases were in the smaller rooms, and when you walk into the main entrance, it is so grand it takes your breath away, as you can see on the screen. The Royal Courts of Justice offers members of the public tours, and I will leave you with the details in the description area if you want something different to do in London. You'll find the tours reasonably priced. So what happened? On the 25th of November 2022, the Court of Appeal Civil Division handed down a decision that undoubtedly will be heartbreaking for the appellants. Appellants are those people who file an appeal with the court. In this case, they are litigants in person, and their argument is that the wording of the abortion law discriminates against the living disabled with Down syndrome, in particular the appellant herself. I will introduce you to her by playing a short clip so you can see for yourself the reason she started the lawsuit. She is a very fascinating person. So let's meet Heidi.
We're spotlighting a brave and beautiful pro-life witness over in the United Kingdom.
The law that allows abortion up to birth for non-fatal disabilities like mine is downright discrimination in the womb.
That is 24-year-old Heidi Crowder last week lobbying for Northern Ireland amendments, which would have provided more protection for the unborn with disabilities. It was ultimately defeated last Friday. This is separate but similar to a lawsuit that Crowder herself has filed in the UK. Crowder, who has Down syndrome, is suing over UK's abortion law, which permits abortion up until birth simply if a baby has Down syndrome. The UK bans abortions at 24 weeks except if there's a disability diagnosis. Crowder says that is discrimination against people with Down syndrome like her. I love her passion for protecting these babies in the womb from discrimination.
So that was Heidi a few years ago, after she filed her claim against the government, specifically the Secretary of State for Health and Social Care. After the divisional courts dismissed her claim, she proceeded for a judicial review and was granted permission to appeal on 2 of the 4 grounds that she had originally claimed. So here we are reviewing this decision by the UK Court of Appeals Civil Division at the Royal Courts of Justice, and I will break down what she was trying to achieve and the reason the court dismissed her case. When reviewing a decision, we look at the arguments made by both sides, then we look at how the court has applied the law. When there is a subjective submission based on an opinion such as Heidi's, we look at the evidence. The government put forth a submission that although it is true abortion laws allow for termination up to 24 weeks and up to birth for non-fatal disabilities, this is somewhat true. However, it is not as straightforward as that. Pregnant women are offered early screening to see if the fetus has serious anomalies, which 44% of women opt out of this screening. So what is an anomaly? Well, a scan is done midway around 20 weeks, and it will look to see if the fetus is developing normally. And Down syndrome is considered by medical science to be a serious disability that can range from mild to serious. It occurs in 0.16% of UK pregnancies. These stats will become important as we need to know how many terminations actually took place, and does an offer for late termination breach human rights, and is it discrimination in the womb to include Downs as a serious disability? In 2019, the stats showed in excess of 200,000 abortions. Out of those, 275 were after the 24 weeks, and this is known as late abortions. And 13 of those late abortions gave the reason for having Downs. Now, the law allows for a late abortion at any stage of a pregnancy if there is a danger to the mother's life and if there is substantial risk of the child being born seriously handicapped. However, late abortions require the opinion of 2 doctors. One of the abortion law's aims is to allow the mother a choice to choose. The reason for this is the law recognizes the responsibility of raising a child, and the mother automatically has this responsibility as soon as the child's born. You can watch my video on parental responsibility. If you want to know more, I will leave a link below in the description area, or you can find it under the playlist as seen here. And for late abortions with a serious handicap diagnosis by 2 doctors, the law also recognizes such reasons as it would be too emotional and could cause financial hardship. Because basically they're saying if a mother believes that she cannot provide a nurturing environment, then the termination can be done after the 24 weeks up to birth for these late abortions. That was a bit of the state's evidence, which of course was the NHS and social care. Now let me tell you about Heidi's submission to the court. Remember, the appeal was allowed to go forward on 2 grounds, Article 8 and 14 of our Human Rights Act. I will explain those in a bit. So the judgment reminds us the appellant, Heidi, feels that the wording of the legislation discriminates, as the language is implying that a person with a serious handicap is demeaning against her, as she has Down syndrome and has been able to live independently, and questions why is there discrimination for people with Downs. It does not seem fair. So the court had to decide if the law was unjustly interfering with her life and breaches her Article 8 and 14 rights. Now, I have done a video if you want to know more about Article 8 rights and how the court would likely interpret them. However, Article 8 is essentially our human rights to private and family life, with no interference by a public authority. However, it is not an absolute right, meaning you can have overriding rights, and a pregnant mother's right to terminate in the first 24 weeks of her pregnancy is her right. And the fetus has overriding rights, and if a late termination were to occur, and it did not fall under the late termination laws, the person aborting the fetus could face up to life in prison. The Guardian did an opinion piece on 2 women currently facing life sentences in August of 2022, titled "Think Abortion is Legal in Great Britain?" Asked 2 women currently facing life sentences. Heidi also submitted to the court that the abortion laws breached Article 14 of our human rights, and Heidi felt that the negative stereotypes that doctors group Down syndrome in as a type of serious disability, which she says is discriminating the fetus in the womb, and that a learning disability is not a handicap. And just so as you know, Article 14 deals with discrimination, which in a nutshell says a person has the enjoyment of rights and freedoms without discrimination on any grounds against their characteristics, such as sex, race, color, language, religion, political or opinion, national or social origins, etc. So to be clear, Heidi was saying that part of the abortion law that allows late termination was an interference in her life, and she says including those who are the living disabled, a term the judge said she continued to use throughout her submissions. So how do you think the courts interpreted the parties' submissions? Well, the court went through the aims of the law and how it was carefully developed by Parliament, and how it relied on 2 doctors to competently carry out screenings and tests to determine if the fetus has an anomaly. The court also accepted that the appellants felt the terminology of the law was offensive, but that is their perception. and went on to say that most are not aware that the law provides late termination for serious disabilities. As remember, 44% opt out of the screening, and late termination is only an offer after an anomaly is found. And the stats indicate that many don't terminate. Different people have different temperaments and different perceptions. The court was very moved by the appellant's statements. However, the court said the wording of the late terminology does not interfere with the rights of the living disabled and therefore does not breach Article 8 or 14 rights. And many will be upset and offended by the fact that a diagnosis of a serious disability during pregnancy is treated by law as a justification for termination, and that they may regard it as implying their own lives are lesser value, but the law balances the rights of a pregnant woman and the interests of the unborn. And there are already laws on discrimination that apply after birth, and if the laws were to be worded differently, it is a question for Parliament, not the courts, and therefore the appeal is dismissed. It is important to also note doctors in the UK take a Hippocratic oath, which varies depending on where they graduate from. On the screen is one university. You might notice in this oath it states that they will oppose policies in breach of human rights. So we put a great deal of trust in them, and the courts acknowledge that they are in the best position to determine if a fetus has a severe disability. In addition, the NHS policies do not actively promote late terminations. In fact, they say they are only available in rare circumstances. And the law does not target Down syndrome specifically. And if you want to know more about late terminations, I have left a link below for the NHS, and their number is on the screen. So the court was of the opinion that the existence of a legal right cannot depend solely on the subjective perceptions of the punitive victim, meaning the negative consequences felt by a victim. And that is something I tell clients all the time. If you are relying on a subjective submission, the court will look at the law and how the average person would behave, and the law will override how the victim perceives. I also did a video on perception, so check out that, as words and perceptions do matter and they can reform existing laws. And if you want to see more about that, I did a video on law reform, so check out that video. Now, I didn't get into case law cited in this appeal that the court commented on. However, the court did point out any inferences with a person's private or family life must be in accordance with the law. But public bodies are not required to do the impossible or impractical. The appellants complained about the very existence of the law and that it interfered with their rights to private and family life, which the court did not accept. The court recognized the appellants genuinely feel offended by the law. I would like to read a message from Heidi that she wrote on Instagram before knowing this outcome. From the get-go, if I was assisting Heidi, I would have said, your arguments are subjective and doomed to fail, but many litigants seeking justice want their message to be heard. I hope her heroism does bring awareness. She has a book out, so check out that in the description area below. Let's read a portion of what she wrote prior to knowing the outcome. Hiya, my lovely friends. I hope you are all well. As you may know, I went to London for the court case against the UK government about their discriminatory laws. She tells a little bit about what she argued for, and then she ends, even if I lose, I have enlightened hearts and minds to the law and the discrimination. Well, she certainly has, and I hope you check her out on Instagram and Facebook. In ending, I can personally understand what Heidi is trying to achieve. As a society, we should value everyone no matter their disability. Whether it be a severe handicap, such as a physical or learning disability, or a mental health issue, each person contributes in a different way. We need social norms to be more tolerant and accepting. So if the laws were to change, then we would need to ensure more funding is available for support. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact Legal Minded Friends.